Good evening, this is John Milburn for Laws 19038. This is week 10, and this week we're dealing with planning and environment law litigation, dealing specifically with criminal law aspects. The first thing that you need to consider is the classification of offences. By that I mean, in simple terms, criminal offences are either summary or indictable. And the distinction is essentially this: that a summary offence is a matter that is dealt with entirely by a magistrate in the magistrate's court. An indictable offence is one, and this is very simple terms, one which is capable of having the presentation of an indictment, which is a piece of paper, kickstarts the prosecution in the higher court. So indictable offences in general terms are dealt with in the higher court, mostly the district court in the state jurisdiction, and a summary offence is a matter that is dealt with in the magistrate's court. And generally speaking, of course, it will come as no surprise that the summary offences are generally of lesser criminality than the indictable offences, which are the more serious offences. But they're just general statements. It is possible, without getting into a whole thing about criminal law, to have indictable offences that are dealt with summarily on election of the parties or must be dealt with summarily. But for the moment, we'll just keep it simple. Summary matters in the magistrate's court, indictable matters in the higher court. But do remember that in order to get to the indictment stage, which is in the higher court, typically the process requires a committal. And a committal is, if you like, a filtering process where the magistrate decides whether there's sufficient evidence to warrant the matter going before a judge and a jury in the higher court on indictment. A committal, the test for a committal is this: whether a magistrate is satisfied that there is sufficient evidence that a reasonable jury, properly instructed, could find the defendant, the accused, guilty of the offence. Not that the jury would find the defendant guilty, or that it's likely, or that it's possible. But it's more just really that it's possible. And one of the common ways that the more serious indictable offences make their way from the magistrate's court to the district court is through a committal that we call a hand-up committal. And a hand-up committal is where a lawyer represents a client in court, typically in court, can be done through the registry as well, but typically in court, and the prosecutor presents various statements, DVDs, photographs, records of interview, whatever evidence there is. And following the presentation of that evidence to the magistrate, and before the magistrate makes any determination as to whether there is enough evidence or not, the lawyer will volunteer on behalf of his or her client information to the effect that there is a concession, that there is sufficient evidence to warrant the matter going to a jury without inviting the magistrate to consider the material. So that's what we call a hand-up committal, and it's something that's a shorthand version designed in part to save the magistrate's court considerable amounts of time in having to churn through what can sometimes be a great volume of material. So I guess the point is this: if you are involved in a prosecution, advising a prosecution authority, or on the other side of the coin, in advising a defendant in an environmental or planning an environment situation, you need to be mindful of whether this is going to be a summary offence or an indictable offence. And sometimes you need to consider the legislation itself, and I'll show you some examples of that shortly. What I would like to do is have a look at some of the legislation that is relevant in this area, and I'm going to share the screen, and we'll have a look at the Environmental Protection Act of 1994 first up. And you'll see here is through OSLI, but there are many ways to access the legislation, the Environmental Protection Act. So in addition to the distinction between summary matters and indictable matters, there are other distinctions that you will see in the legislation in various parts. For example, Section 16 deals with prosecution matters that involve material environmental harm. and you'll see the threshold for that serious environmental harm is $5,000. Consider, that's material environmental harm, as opposed to the next section, 17, which deals with serious environmental harm, and the threshold there is $50,000, so considerably much more serious. So the point there is that if you're involved in advising either prosecution or defence, think about what is the appropriate charge. And sometimes if you're acting for a defendant, you will try to categorise a charge so that it is the lesser version rather than the greater version. So part of your job is to carefully consider the material and see if there's some way out. Even if it looks like a lost cause, it may be that by requesting a downgrade of the charge, you'll save your client much in terms of penalty. And I guess it's an exercise partly in damage minimisation. But apart from considering some of those threshold questions, is this a summary offence or is it an indictable offence? Does the legislation prescribe the nature of the offence? For example, a material environmental harm or serious environmental harm. If you're acting for advising a prosecutor, or more particularly if you're advising a defendant in planning and environment law, criminal law litigation, you might consider some defences that are available. And some of the defences that are available in P&E criminal law litigation are available generally in criminal law prosecutions. Now, I'm talking tonight about the state jurisdiction. There is, of course, the federal jurisdiction as well, but many of the things that we're talking about at the state level also apply at the federal level. Now, in terms of defences, I'm going to show you 4 potential defences. Keep these in mind if you're acting for a defendant particularly and you want to know whether you can successfully challenge the prosecution and ultimately secure a not guilty verdict. I'll share the screen and we'll now have a look at the criminal code. The criminal code is, of course, a piece of legislation in Queensland. Again, going through OSLE, we go to Queensland legislation, C, down to the criminal code. Now, just bear in mind, it's not the Criminal Code Act, it's the criminal code itself. Criminal code is essentially a schedule to the Act. So here's the criminal code, 1899, but modified extensively since then, of course, as you might expect. Chapter 5 deals with criminal responsibility, and there are a number of defences that might be available to offenders generally, but let's identify 2 that may have bearing on environmental or planning and environment litigation. The first is section 24, and that deals with a mistake of fact. A person who does or omits to do an act under an honest and reasonable but mistaken belief in the existence of a state of things is not criminally responsible for the act or omission to any greater extent than if the real state of things had been such as the person believed to exist. So we call that the honest and reasonable mistake of fact defence. So if your client, if you're from a defence perspective, fits within that definition and is honestly and reasonably mistaken about a factual issue or factual issues, then it may be that you can advance an honest and reasonable mistake of fact defence. The fact that it's under the criminal code does not stop it from being available in planning and environment law litigation involving criminality. Let's have a look at the next one, and that is extraordinary emergency. And essentially, if there is an emergency or something that is outside the control of the offender, then section 25 might be relied upon successfully to secure an acquittal. But it's not just the criminal code where one must consider potential defences. Defences are also available under specialist legislation, and it'll come as no surprise that the Environmental Protection Act is a key piece of legislation when it comes to prosecution in relation to planning and environment court issues. One defence that you should keep up your sleeve is the general duty defence. Section 319 provides that everyone has a general environmental duty. And it essentially says that a person must not carry out any activity that causes or is likely to cause environmental harm unless the person takes all reasonable and practicable measures to prevent or minimise the harm, which is the environmental duty. So when you're looking at it from a defence perspective, I always look at this part here, unless the person takes reasonable and practicable measures to prevent or minimise. So from a defence perspective, you zero in on that exclusion or that exception, if you like, to the law, to try to show that the person attempted to take reasonable and practical steps to minimise or prevent the harm, and that would be your duty. Another thing that you could consider, also under the same Act, is the issue of due diligence. And if we look at section 493 of the Act, you'll see that there's a general statement to the effect that executive officers, this is of a corporation, must ensure the corporation complies with the Act. And it is a defence in subsection 4 for executive officers to prove a number of things in relation to the alleged offence, and that is that they took all reasonable steps to ensure the corporation complied with the provisions. So that due diligence defence is also a general defence that you should keep in mind if you're advising someone who is under the hammer, so to speak, in terms of potential criminal liability. But also keep it in mind if you're advising a prosecutorial authority, because it may have a bearing on whether to proceed. One of the things that you should consider is this, particularly from a defence perspective. Are there different ways entirely to deal with the issue as opposed to dealing with a criminal behaviour? So administrative orders, for example, may be a different way of dealing with the issue. But let's have a look at contempt hearings, and this may be a different way to deal with alleged planning and environment litigation. So if we look at the Sustainable Planning Act, you'll see section 439 provides for the court to deal with contempt and contravention of orders. And that may be the appropriate way to either prosecute or defend a matter that relates to planning and environment court breach. So when it comes to dealing with these sorts of issues, bear in mind that there may be a number of different ways to deal with what appears to be a straightforward criminal prosecution. It may be that you can, as defence, convince the prosecutorial authority to proceed in a manner which does not involve a criminal complaint. Or it may be that if there is a criminal complaint, you need to deal with issues of trying to downgrade that complaint so that it's not serious environmental harm, but it's material environmental harm. Also, think about whether the matter is dealt with in the magistrate's court or the district court. That may have a bearing on negotiations, and it may have a bearing on cost issues and timing issues, and also potential penalties. So there's a number of things that you need to consider in that context. But if you do find you're in a position where a prosecution has been brought successfully, in the sense that after a trial, the court or the jury or the magistrate, as the case may be, comes to a finding of guilt, or if the defendant pleads guilty, then we need to go through a different type of process, which is called the sentencing process. And sentencing is that process where the court imposes a penalty for the criminal activity. But the court is constrained by a number of things, and one of the important things, and I'm talking now at a state level, is the sentencing guidelines that are contained in the Penalties and Sentences Act. So that is an area where you need to consider the penalty. There is a question online. So would Section 24, mistake of fact, be quite hard to provide evidence on? And the answer is yes, it can always be difficult to do that. So mistake of fact is where you say, I honestly believe that this was the case. I'm wrong, but from a factual perspective, I thought that was the case. Perhaps the best way of describing Section 24 defence of mistake of fact is to give some idea of what used to happen before legislation changed to make it almost impossible to find. And that was in relation to drink driving. The level of drink driving, the level of alcohol in one system, is a factual issue. It's a fact that the reading was 0.0, or it's a fact that the reading was 0.08, for example. What used to happen is this, that people would run a defence to say, look, I was over the reading. I was, back in those days it was 0.08. The reading is 0.09, but I honestly and reasonably thought that I was under the limit. And we would run that as a mistake of fact defence. The law changed and said you can't do that anymore. We're not going to allow mistake of fact defences in relation to drink driving. So it ruins some fun for defence lawyers. So in that sense, mistake of fact is showing the subjective, showing what's in someone's mind, I guess their opinion about the state of affairs, but it has to be honest and has to be reasonable, although mistaken. All right, so let's talk about the penalties and the way in which those penalties are imposed by a court. And we do that by reference to the Penalties and Sentences Act. So again, this is the Queensland. The Commonwealth counterpart would be in the Crimes Act. Penalties and Sentences Act, Queensland, 1992, provides the governing principles, guidelines and rules that relate to the sentencing process. Section 9 is particularly important because it provides the sentencing guidelines in a general and specific sense. And as a defence lawyer, I have this handy and use it both in terms of taking instructions from clients and also making submissions to the prosecution about the prosecution matter, but also finally in court in trying to, I suppose, put submissions before a court to ask the court to emphasise certain aspects that might be advantageous to your client. So in general terms, there are certain purposes for which sentences may be imposed upon an offender. One of those is to punish an offender to an extent or in a way that is just in all the circumstances. So what that might mean is that from a defence perspective, you say, well, yes, but in passing sentence, Your Honour, you must do so in a way that is just in all the circumstances. And here are some circumstances that we, defence, believe are important circumstances that must weigh heavily on Your Honour's discretion. Another was to protect the Queensland community from the offender. So it may be that the offender has taken remedial action to make it possible for a defence to submit that it's not likely that the Queensland community will need protection from this offender for various reasons, and therefore the sentence that is imposed need not include that element of, I guess, restraining, if you like, the offender through the imposition of a harsh penalty. And also, the court needs to consider certain things, such as the offender's character. So if you can establish that the offender is of good character, you do that through references or other documents, it may be that that will assist the court, the defendant, in that the penalty will be reduced accordingly. So do have a look at the Penalties and Sentences Act. In particular, have a look at Section 9, the sentencing guidelines, and rather than simply read it as a list or acknowledge its existence for future reference. Think about a case where there is a prosecution and think about how the court may have been directed to consider some of these guidelines in the process of sentencing. So when it comes to dealing with environmental or planning and environmental law, criminal law prosecutions, there are a few factors that you need to consider in terms of negotiating, taking instructions, deciding whether there's a defence or not, and ultimately, if there is a finding of guilt, presenting to a court that might help in the process of sentencing. Also, it's important to remember that there are different types of causation in criminal law context. I'll share the screen once more, and this will be the last time I do it. Let's have a look at the Environmental Protection Act again. And if I could draw your attention to section 437, it's in two parts, and there is a significant difference between the two parts. So we're here specifically dealing with offences relating to environmental harm. And before, we saw the definition of offences that cause serious environmental harm, which was 17, and offences that cause material environmental harm, which was 16. So in terms of criminality, let's see how that plays out. So offences of causing serious environmental harm, section 437 subsection 1 provides for maximum penalty of 6,250 penalty units or 5 years imprisonment. Now that might have a bearing on whether this is indictable or not, in circumstances where the person has willfully and unlawfully caused serious environmental harm, as opposed to subsection 2, where there's a lesser penalty and no imprisonment provided for, in circumstances where the person has unlawfully caused serious environmental harm. So the issue of willfulness is taken away. So when you're representing a client charged with prosecution or advising the prosecutorial authority about to embark on criminal prosecution, you need to consider whether or not there is that extra element of willfully causing the harm. If we go to the next section, 438, you'll see something similar, but in relation to material environmental harm, which of course through the definitions we know is less serious than serious environmental harm. You'll see the reduction in the penalties to reflect the less serious nature. But again, we have that distinction between acts which are willful as opposed to acts that are unlawful but not necessarily willful, and there's a much lower penalty. There's just one other thing that I will draw your attention to, and this is the last thing, so we're about to wrap up. Section 24 of the Environmental Protection Act, now this is of course entirely different to Section 24 of the Criminal Code that we looked at before, but Section 24 of the Environmental Protection Act provides that the Act does not limit any civil right or remedy that exists, whether at common law or otherwise. So what that means is that the imposition of a penalty for criminal law behaviour upon a defendant does not preclude a person from pursuing civil remedies for damages against that person if they believe they have a civil case. In fact, there is provision in our rules of evidence to suggest that, or to state, that a conviction for a criminal offence can be used, and probably should be used, in criminal law, civil law proceedings after the event. All right, well, I'm not sure there's any questions or comments, but other than that, I'll wrap it up for this week. Thank you for attending, and we'll see you next week.